Before proceeding with considering the questions of the case, the court had to decide the merits of the case, which depended on the nomenclature associated with the Affordable Care Act. Could the court review the individual mandate enforced by the Affordable Care Act, even though the provisions of that act would not go into effect until 2 years later? Under the Anti-Injunction Act, individuals are prohibited from suing the federal government to stop the collection of that tax until it becomes effective. This act would enforce a tax administered by the Internal Revenue Service if individuals do not purchase health insurance. The state plaintiffs argued that the purpose of the tax would be to encourage individuals to purchase insurance, not to raise revenue, and should therefore not be protected from judicial challenge under the Anti-Injunction Act. However, Congress used the word tax to describe some portions of the statute, but not the mandate, so it is reasonable to infer that Congress did not intend for the Anti-Injunction Act to apply to the penalty. We argue that the Anti-Injunction Act does not apply to the individual mandate penalty, and thus the individual mandate is not barred from the court's review until it becomes effective in 2014. A penalty is assessed for failure to purchase qualified coverage, and the assessed penalty is challenged.
Whether the individual mandate can be separate from the Affordable Care Act, the issue of severability does not apply because minimum coverage provision is constitutional. And even if severability is considered, the Act should still stand regardless of whether or not the individual mandate is unconstitutional, because the minimum coverage provision is a constitutional exercise of Congress' powers. This court does not consider the issue of severability. The severability of most provisions of the Act may not be considered in this case. NFIB seeks to invalidate a number of provisions that do not apply to them. If the court were to hold the minimum coverage provision unconstitutional, such a holding would provide no basis for the court to consider the continued validity of countless other provisions of the Act that do not apply to petitioners. The court should not consider the validity of provisions of the Act that are not directed to NFIB. The severability claims do not apply because NFIB are not insurance and cannot make this argument as they are a third party. This is supported by Prince v. United States. As Prince demonstrates, there is no insurability exception to the rule against educating claims involving only the rights of third parties. Insurance companies are ambiguous in this case, but they are not making any argument about severability. If the courts deem the individual mandate constitutional, then NFIB cannot seek to invalidate parts of the ACA if they are constitutional. The individual mandate is essential to the Affordable Care Act and the incentive to expand access to affordable health care. All parties agree that the minimum coverage provision is necessary to make effective the Act's guaranteed issue and community rating insurance market reforms. Other provisions can operate independently and will still advance Congress' core goals of expanding coverage, improving public health, and controlling costs, even if the minimum coverage provision were held unconstitutional. While those other provisions could have been enacted without the individual mandate, they were enacted in the context of ACA's purpose of achieving near universal coverage. Because many provisions of the Affordable Care Act, including a number of provisions that are already in effect, help to advance the overall goal of the Affordable Care Act, the Act should still hold, even if the individual mandate is found to be unconstitutional.
Under the Commerce Clause, as outlined in Article 1 of the United States Constitution, Congress has the power to regulate activity that substantially affects interstate commerce. The individual mandate of the Affordable Care Act, which requires all individuals to purchase a minimum level of health insurance coverage, is both economic and commercial in nature. Seeing as healthcare is both bought and sold at the national and regional level, it falls within a category of commerce that can be regulated by Congress. The healthcare industry is one of the largest sectors of our economy. The economy loses over $200 billion a year due to the poor health and the shortened lifespan of uninsured Americans. When more individuals choose not to purchase health insurance, the financial burden increases for insured households as well as for medical providers. Health insurance premiums and administrative costs skyrocket, and this is a primary issue of Congress's concern in enacting this mandate. Petitioners make the claim that Congress is attempting to regulate inactivity in healthcare commerce. But it becomes important to note that all Americans at some point in their life, if not already, will be actively participating in healthcare commerce. With that said, the main goal of the individual mandate is to change the way that healthcare goods and services are purchased in the first place. So rather than purchasing healthcare when needed or once in a while, this mandate seeks to ensure that these services are purchased preemptively at a minimum level and proactively maintained in order to prevent a number of economic and social consequences that come as a result of having high populations of uninsured individuals in America. We assert that the individual mandate is not Congress's attempt to force commerce or force activity in commerce. No one is being forced to buy insurance. People can still refuse. However, those who do not comply with the mandate have to pay a penalty fee, and they have no control over that. This fee, however, is the government's attempt to incentivize a behavior that will help reduce a number of issues that are pressing the nation as a result of high levels of uninsurance. Furthermore, the petitioners would like to argue that allowing Congress to enact the individual mandate under the Commerce Clause is an unprecedented or an unlimited expansion of congressional power. However, this is not the first time that Congress has regulated an action that has not yet happened. This is not a novel execution of congressional power. We can look at a few examples. For example, the Controlled Substance Act. Any individual who had a controlled substance prior to the enactment of the law had to dispose of that substance. And if they didn't, which is inactivity, they would be penalized. The same thing happened in the state of Massachusetts. The state refused to conduct business with any companies that did business in Burma. And the court held that this was a violation of federal statutes under the Foreign Commerce Clause. So essentially, we argue that Congress has the power to regulate both activity and inactivity when it pertains to reasonable means of regulating interstate commerce. And in this case, enacting the individual mandate and regulating interstate commerce is a constitutional execution of the Commerce Clause.
Does the necessary and proper clause constitutionally allow Congress to serve an individual mandate? The necessary and proper clause gives Congress the ability to make all laws which shall be necessary and proper for carrying into execution under Article 1, Section 8 of the Constitution. The individual mandate is necessary because everyone will need health care at some point in the future, whether it is near or far. If people don't have insurance, they often are not able to pay for hospital fees, and the hospitals end up passing the losses onto insurers through higher premiums. There is also the issue of people not being able to find insurance coverage because they have pre-existing medical conditions. The individual mandate forces insurance companies to guarantee insurance to individuals that have these pre-existing conditions through the guaranteed issue part of the Act. The individual mandate was the solution to both of these problems that were brought up by Congress. The mandate helps prevent cost shifting by requiring individuals to purchase health insurance who would otherwise go without it. The court, on numerous previous occasions, has ruled that necessary does not mean absolutely necessary, but means useful to advancing objectives. The individual mandate is necessary to preventing the cost shifting issue that the country is facing today.
Does Congress have the power to enforce the individual mandate penalty? The plaintiff's argument is not that Congress does not have the power to tax American citizens for not having health insurance, but rather that because the language used in the Affordable Care Act legislation is that it is a penalty rather than a tax, means that Congress does not have the power to enforce it under Article 1, Section 8, Clause 1 of the United States Constitution regarding Congress's power to raise and levy taxes. To decide whether Congress can place this penalty on citizens under the guise that it is in fact a tax, the definition of a tax must first be established. There are multiple components to a tax. First, that it is a compulsory financial payment and the refusal of such is punishable by law. The second, that it is made in the general interest of the nation. Third, it is a legal correction. And 4, that it is made payable periodically to the International Revenue Services. So it is fair to say that if the legislation made by Congress meets these categories, it does not matter what wording they call it by, it is still a tax. The penalty incurred by the individual mandate meets all 4 of these categories exactly as a tax would. It is a compulsory financial payment for anyone who does not have health insurance and or who refuses to buy the insurances provided by the Affordable Care Act. It was made with the benefit of the nation in mind, since Americans without health insurance place an enormous cost on the health insurance market, and it would benefit all American citizens to have insurance in case of emergencies. It does incur a legal correction for anyone who does not have health insurance, and it was made payable periodically to the International Revenue Services, as listed within the Affordable Care Act. For these reasons, it does not matter if it is called a penalty or anything else, since it functions exactly like a tax and meets all the requirements laid out to be a tax. This means that the argument presented by the plaintiffs does not hold and cannot be valid means to prevent this tax, labeled by Congress as a penalty, since the original argument was that it was not a tax to begin with. Congress was given the power through Article 1, Section 8 to create and levy taxes so long as they are made for the general welfare of the nation and that they are uniform throughout the nation. This penalty, now clearly defined as a tax, meets each of these requirements, so it is valid as a tax within Congress's taxing power.
The enactment of the provision for Medicaid expansion and its condition that non-compliant states may forfeit all of their federal Medicaid funding is fully within Congress's powers under the spending clause. In South Dakota versus Dole, the court delineated 4 general restrictions on legislative power under the spending clause. First, the exercise of congressional power must be in pursuit of the general welfare. Second, any conditions attached to the receipt of federal funding must be enacted unambiguously so as to enable states to exercise their choice knowingly with full awareness of the consequences of their participation. Third, conditions attached to federal spending must be related to a national concern. And fourth, other constitutional provisions may provide an independent bar to conditional grants. The plaintiffs claim that the Medicaid expansion violates this second constraint by failing to clearly outline the conditions for receiving federal Medicaid funding in order to ensure that the states are fully aware of the consequences of complying with the provision or failing to comply. Despite this fact, there has been plenty of precedent for the conditions attached to the federal program, and furthermore, given the increased federal contributions to the costs that the states have to undertake for expanding these programs, the plaintiffs have to undertake very little burden, so these conditions cannot be considered burdensome. The plaintiffs also claim that the conditions attached to the provision coerce the states into participating. There have been several instances over the last few decades of enlargements and transformations to the Medicaid program, where the scope of Medicaid eligibility as well as the Medicaid benefits have been expanded, yet states have been forced to either comply with the changes or risk losing all of their federal Medicaid funding. And in each of these instances, the states have amended their plans and their programs to consist with all of the changes in federal law. More importantly, in 1965, when Medicaid was first passed into law, Congress gave the states notice that it retained authority to make any changes to the Medicaid program. This fact, in and of itself, should remove any sort of possibility or concern with the conditions of the provision being unconstitutionally coercive. As the states have in the past, the states must accept that the Medicaid expansion is simply a condition of their participation in the overall program, rather than being a condition on receiving increased federal funding. The sheer size of the Medicaid program does not make the conditions attached to the provision unconstitutionally coercive, because it has been the largest federal grant and aid program, yet states have continued to participate in the face of numerous expansions and numerous changes over the years. A parallel to this situation is how the court ruled in South Dakota versus Dole. The court similarly ruled that it was not coercive for the federal government to condition the receipt of federal highway funds on states maintaining a legal drinking age of 21 years old. And in a similar way, Congress is simply imposing conditions to regulate how states are using federal Medicaid funds. So, as the Court of Appeals for the 11th Circuit very correctly ruled in upholding the constitutionality of the Medicaid expansion, states enrolled in Medicaid have a very real choice of either continuing their participation in the Medicaid program or leaving altogether.